you very much. My name is Tina Stowell. I chair the Communications and Digital Select Committee in the House of Lords, and I'm very pleased to have been asked to chair this session this afternoon, where we're going to look at the regulatory developments here in England and Wales in respect of SLAPPs, and also the implications of the changes that are being made here in England and Wales to other jurisdictions. Let me introduce my colleagues here on the panel alongside from me. We have, hopefully joining us online, it will be Dr. Susan Hawley from Spotlight on Corruption. And then to my right, we have Juliet Oliver from the SRA, Sam Tannand from the Bar Council, and Richard Orpin from the Legal Services Board. And when I'm going to ask them to speak for about 5 or 6 minutes, just to give us their reflections on the questions of regulation in the legal profession in this context. And I may have a couple of questions to follow up with what they have to say, and then I'll invite Charlie Holt to give us some of his thoughts on the basis of what he's heard, and also a bit of a perspective from other jurisdictions, and then we'll open it up to the floor. And I should just say, in terms of the Communications and Digital Select Committee in the House of Lords, we first looked at the topic of SLAPPs about 18 months ago now, when the matter first came into the public conscience as a consequence of a number of Russian oligarchs doing their worst, as it were, or trying to. And we held a hearing then, and then we had another hearing earlier this year, and I tabled some amendments to the economic crime bill that has now been passed. And one of the things that we did as part of our sessions on this was to invite the SRA to give evidence to us, because I was clear that one of the aspects that needed to be properly understood was what actions were possible against the legal profession if they were acting in a way which was assisting those who seek to abuse our judicial system in this way. So that was where my interest came from, and I'm very pleased, as I say, to be here and to chair this session. But Juliet, so Susan's going to start us off, I think. Susan, are you there?
I am here. I'm very sorry I can't join you in person.
There you are. Very good. Susan, why don't you kick us off and give us your perspective on this topic?
Yes, thank you. Well, I kind of go a bit big picture and really look at some of the issues why SLAPPs are so important. We were earlier this year subject to the threat of defamation. And it really is extraordinary how much time and effort and stress it takes to deal with this threat. And as a charity, we how much kind of charitable resources we actually had to divert to dealing with it. And I think as a kind of non-lawyer, it's really extraordinary how much can ride on the turn of a phrase, very complex democratic arguments, which one would have no idea about when one was writing something. Hopefully we've seen it on. But one of the things we heard about in the course of responding to that threat is that some people clearly see the defamation process in the UK as a money spinner and actually as a way of bringing in supplementary income. And I think if we're in a situation where UK libel laws can be abused to silence and threaten of individual financial gain, there is something seriously wrong. The thing that I wanted to highlight from my experience was that, can I just ask, I'm getting a lot of feedback. Can you hear me okay without the feedback?
We're hearing you. I mean, I think the sound, it could be better. I'm looking at colleagues from the sort of production side, but I'm just wondering whether, whilst we're looking at the technical aspects for you, Susan, maybe we should move on to the other members of the panel, and then we can come back to you at the end, because I think it would be helpful to hear a bit more about how you and have perhaps worked with regulators, or where you see you can work with regulators in this area. But let me move then to Juliet to get the SRA's perspective on what work you've been doing since this event last year.
Thank you. Yes, and thanks for having me back again this year. So just as a reminder, the Solicitors Regulation Authority regulates solicitors and law firms in England and Wales. And I thought I would start with a bit of a background to our approach to the issues and where we've been kind of coming from on this. So we've got a broad regulatory framework of rules and standards in place to allow us to address the abuse of the litigation process. We've been clear for many years that this is unacceptable, and that while solicitors must act fearlessly in their clients' interests, they are officers of the court, and they have overarching obligations to act with independence and integrity. So we very much welcome the economic crime legislation and the new powers for the courts surrounding SLAPPs. But I just wanted to start by making clear our powers aren't contingent on that legislation or limited to economic crime. In March last year, following the Russian invasion of Ukraine and the raised profile of the issues, we consolidated and reissued our guidance about how our rules and standards apply to abusive litigation, referring for the first time then specifically to SLAPPs. And we clarified that solicitors shouldn't, for example, make claims where the merits are unfounded or exaggerated. There's a regulatory obligation to make sure all claims are properly arguable, or to use litigation tactics to drive up costs or delay proceedings or intimidate opponents. Before that time, we had a very small number of reports to us of concerns. These escalated quickly after our guidance was issued, and we set up a dedicated case handling team to look at them. And given the concerns in this space, we also carried out a thematic review, visiting a number of firms acting on both sides, both claimant and defendant, in the reputation management space, to understand better how firms approach their obligations in practice. Recognising that this was just a snapshot of a sample of firms, and at risk of summarising the results sort of wildly, I just wanted to highlight that we found that the level of awareness of our obligations, the level of awareness of our guidance was disappointingly low. And we found that most firms didn't have any formal policies and procedures in place in relation to these issues, in relation to how our obligations applied in this context. So informed by what we were seeing, we followed up our guidance in November with the publication of a warning notice specifically on SLAPPs, and a companion piece for those on the receiving end, so that they can understand what and how to report to us. The warning notice highlights red flags for firms to look out for, as well as problematic behaviours, such as bringing a claim in defamation where it should be clear that the truth defence would be successful, or using misleading labels in correspondence, such as without prejudice or private and confidential, where those labels aren't appropriate or their meaning or consequences aren't properly explained. As you might expect, I can't talk about individual cases that we're handling, but I did think it might be helpful to give you a sense of the shape of our caseload and what we've been seeing. We're currently investigating around 50 cases specifically relating to allegations of SLAPPs. And 6 more relating to abusive litigation tactics, but in a different factual context. We have 2 abusive litigation cases which have been referred for determination before the Solicitors Disciplinary Tribunal. We also have a handful of cases related to SLAPPs, which are now at the stage at the end of our investigations where we're recommending action, referral to the tribunal, or a sanction such as a fine. And we put the allegations to the solicitor or firm at that stage for their representations before making a final decision. 19 cases have been closed without action. And for example, what we see in some cases is that while the correspondence and issues are clearly concerning for the complainant, the evidence doesn't show that the approach itself was improper, so that it amounts to misconduct. But in some of those closed cases, We've used our powers to issue formal advice to highlight to the solicitor or firm that they've done something wrong. So, for example, they've used inappropriate tone or language in correspondence, or haven't fully explained to the other side what it is that is said to be defamatory in what they're doing. So in those kind of cases, while they're not serious enough for us to take formal action through a sanction, we keep a record on file in case the behaviours are repeated. Most of the cases we do take forward aren't straightforward. They tend to involve novel issues, often testing complex and technical areas of legal practice, as well as being quite complex factually and document heavy. And we know there are particular touch points that often come up in cases before us. For example, the right to reply process, where deadlines can be extremely tight and the amount of information available can be very limited. We've just completed a follow-up thematic review, looking at the response to our warning notice across firms and talking to in-house lawyers in media companies and others such as the Foreign Policy Centre. We're also updating our warning notice to reflect some of the further work we've done, what we've seen in our casework, and the thematic review. And both of those are still in development, but we have completed our field work, with the huge caveat that this is still work in progress, so not to be quoted as the final picture. I wanted to finish off by sharing a few emerging themes from the review and our wider engagement. So first of all, in the latest thematic review, we can see that the levels of awareness of our obligations are improving and demonstrate a real shift from the previous thematic. Indeed, the vast majority we spoke to had received training, most of which had taken place in the last 6 months to a year. We heard that the warning notice is impacting day-to-day work, and we heard of changes to working practices. So, for example, much more caution around the use of labelling correspondence. And in-house media lawyers also reported they'd noticed some positive changes in claimant law firm behaviour, for example, around the labelling and also the tone of correspondence. One thing we heard about was some ambiguities in the role and remit where firms are working together with PR firms and private investigators. We heard about a degree of informality when lower firms are instructing these external agencies, although often we heard they're instructed by clients directly. And finally, we heard a real desire from all quarters for more case examples to illustrate our guidance on good and poor practice. And we're in the process of developing that. So I'll stop there, but I thought that just finally to say thank you to everybody who's been involved in our work and for reporting issues to us.
Okay, so lots of activity from the SRA. I've got some questions which I'll come back to in a moment, but let's move to Sam and find out what the Bar Council wants to tell us about their activity in this space.
Thank you very much, and good afternoon, everyone. So I am the Vice Chair of the Bar Council of England and Wales. We delegate our regulator functions to a board, something called the Bar Standards Board, which is the bar equivalent of the Solicitors Regulatory Authority. So I'm here on behalf of the representative body, on one view the trade union, if you like, of the bar, not here as the regulator. That would be the Bar Standards Board. First of all, if I could say this, misconduct of any kind needs to be stamped out. The bar owes a host of duties of conduct, abuse of process, litigation for collateral purposes is not permitted. We owe duties to litigants in person, and we of course owe duties to the court and duties not to mislead and so on. We have a handbook which details all of the duties and obligations that a barrister has, and if they breach that, the book should be thrown at them. So please don't misunderstand me in relation to that. I think there's three things one needs to look at in this space. One is to identify with precision what is the problem. What's the problem that requires resolution? Secondly, what is going to work? If one identifies there's a problem, we need to have a tailored solution to it. And then will that actually get to the root of the problem, the mischief? Now, Juliet's already helpfully referred to the thematic review which the SRA carried out about 8 months or so ago. They visited 25 law firms, conducted interviews and file reviews, including, I think, 2 closed files for each of the 25 law firms. So they looked at 50 closed files. These were all defamation solicitors. And they found, and this is in the press release, they found no evidence of the firms we reviewed abusing the litigation process. They did, however, find solicitors were not aware of the latest guidance in conduct in disputes, and there was, as Juliet said, a lack of policies and procedures for this work or specific training for fee earners on how to conduct fair and appropriate litigation. But the important point, I think, from our perspective, is to identify that there was no example of SLAPPs. Admittedly, Juliet will say, because I've heard her say this before, they weren't specifically looking for that, but nevertheless they found no evidence of it, which I think is telling and important. So what is the problem? I think the problem comes in, and this is where people like Dan Needle, Tom Burgess, Daniel Giogan, Charlotte Leslie, she's unlike the others, she's not a journalist, of course, she's a former MP, with the aggressive nature of letters before action, correspondence at the beginning. And I think now that we have the Economic Crime Act, I think the problem turns to the difficulties faced by investigative journalists in particular, and obviously in non-financial crime areas. I think 30% that's not covered by the Economic Crime Act. That's where I think the difficulty lies. Of course, much of that goes on behind the scenes. Much of it doesn't. I mean, you could see all those individuals that I've mentioned, they've all subsequently spoken about their difficulties, or indeed they're covered by reported cases, such as the Mercy and Leslie case. In one sense, they show that the system has worked. I appreciate that it hasn't worked altogether, and I am going to assume for present purposes there is this problem, if you like, at the beginning of the process. So then, what is workable? There are 2 possible approaches that have been canvassed. If I could characterise one of them as the regulatory approach, and it's good to hear everything that Juliet has said. Obviously, regulation has its place. One needs to, there are obviously before the event regulation, which is policies, compliance activities, and so on. And then there's after the event, the throwing the book at the lawyer that's committed misconduct. And I have no difficulty with the second at all. Is there evidence of a poor culture of lawyers as distinct from their awful clients? I mean, I put that to you quite bluntly. The SRA thematic review didn't, in this case, find any evidence of SLAPPs. They found a failure to comply with guidance and to be up to date on policy, but that is different to being involved in a SLAPP. The effect of before the event regulation, if you like, is necessarily not targeted. It could be targeted at defamation solicitors, but it's not targeted at the bad actors. 95%, or in the example of the 50 closed files, no one was involved in the bad acting. So we need to be quite careful about imposing further regulatory burdens on certainly on the bar, where there isn't any evidence through case law or otherwise of any bar-specific problem. Anyway, I'm not just being a negative person on this topic. How can we actually resolve the problem? Well, we've proposed a number of practical solutions that we think go to the substance. In all these cases, there's a threat of court action. Otherwise, the aggressive letters lack any bite. And what one needs to look at, in my view, what that court action consists of. And Dan Needle, when he's talked about this, one of the points he's identified is the chilling effect of the correspondence, in particular with an eye to the costs that might be involved, such that the journalist and their editor see the downside risk, and it causes them not to pursue their inquiries or continue with publication as they might. And I was at the UK, the Department for Media and Sport task force meeting, and Daniel Giogan said in similar terms that was one of the factors, that media organisations decide they can't take the risk. So we proposed a number of possibilities. One is to change the cost position so that you restore a balance between what is otherwise inherently an imbalance between the perhaps oligarch or other very wealthy individual and the individual journalist or other person. One of those solutions, which takes place in a different context, is qualified one-way cost shifting. So that would mean that the person bringing the claim would ordinarily have to carry the costs of both sides. There could be exceptions to that, for example, where the defendant seeks a determination that the case constitutes a SLAPP with no reasonable grounds for doing, or for reasons that are abusive, or where the defendant's conduct obstructs the fair disposal of the proceedings. And you might be able to revisit that. But if you have qualified one-way cost shifting, in large part you remove the costs pressure on the journalist and their small media firm behind them. Another possibility...
we're running out of time.
Okay. Well, there's two other possibilities, and this is slightly techie. I'll just identify it,
right,
so that we can then perhaps come back to it in questions. One is our House Convention claims, which are in the environmental sphere for judicial review, where you take into account people's means when it comes to costs and assessing costs. And the other one is this question of whether in privacy cases you could have an enhanced cross-undertaking in damages, which would mean, again, there would be a real burden, a cost burden put on the applicant, the wealthy applicant, and the lawyers, importantly, would have to advise about all of these costs issues, or they would be negligent in not so doing. That is the sort of, if there's a culture change needed, and there's a burden on the lawyers to advise on negligence, that's the sort of thing I think would have real positive effect.
Okay.
Thank you.
Thank you. Let's move to Richard and the Legal Services Board, which has this oversight responsibility of both aspects of the legal profession.
Thank you. Thank you very much for the invitation to speak today at such an important event. I'm Richard Orpin, Director, Regulation and Policy at the Legal Services Board. And as Baroness Stowell says, we're the oversight regulator for legal services in England and Wales, which means we oversee the work of the Solicitors Regulation Authority, the Bar Standards Board, and a number of other frontline legal services regulators. We're a statutory body established by the Legal Services Act 2007, and we're independent of both government and the profession. I'd like to talk about the contribution that regulation can make on the issue of SLAPPs and on other forms of misuse of the law. The Legal Services Act, which describes our functions and from which we draw our duties and powers, sets out several regulatory objectives that we and the legal services regulators we oversee must promote. They include supporting the constitutional principle of the rule of law, promoting and maintaining adherence to the professional principles, and most recently, promoting the prevention of and detection of economic crime. In our view, the issues underlying SLAPPs are questions of conduct, questions of integrity, the maintenance of proper standards, and above all, acting in a way which is conducive to justice being served. These behaviours are at the heart of the professional principles we and the other legal services regulators have a duty to promote and ensure adherence to. In our view, then, there's no doubt that these are rightly matters for regulators to consider. It would also be remiss of me not to point out that SLAPPs isn't the only area in which questions about the ethical conduct of legal professionals have been raised. A closely related example is the misuse of non-disclosure agreements. At the LSB, we recently published a call for evidence on the misuse of NDAs to seek views and evidence on concerns about the important role that legal professionals can play in ensuring that NDAs are not misused to conceal wrongdoing. We're currently analysing responses, which may lead to proposals to help strengthen the arrangements in place to ensure that lawyers do not facilitate such misuse. The Post Office Horizon IT inquiry continues to shine a light on the conduct of legal professionals, and we've also heard growing concerns amongst the profession itself about the difficulties faced by in-house counsel in navigating the many challenging conflicts they face. It's clear, therefore, that issues around ethical conduct among legal professionals are not confined solely to SLAPPs. But let's return to the matter before us here. We've already heard much today about the potential benefits of the new anti-SLAPP legislation. But there's also a recognition that, while welcome, the Economic Crime and Corporate Transparency Act only gets us so far. While it's of great value that there will be in future a mechanism for a court to throw out a SLAPP, a good SLAPP will never make it to court in the first place. Much of the harm that arises from their use happens well before a case ever gets before a judge. In our view, this adds further weight to the argument that there is a role for regulation to complement the legislation that's recently been enacted. Regulatory solutions can be delivered often more quickly and need not be limited to economic crime alone. They apply to lawyers' conduct from the moment they become involved, regardless of whether a case ever gets to a court. It's clear then that there's a role for regulation to play in ensuring ethical standards are maintained. But what form might that take, and to what extent is existing regulation capable of addressing these harms if it were applied more robustly? At the LSB, we're leading a programme of work which will seek to answer questions of this kind. Right now, we're working with a wide range of stakeholders to gain consensus on the types of conduct which are not consistent with upholding the rule of law. We've joined the government task force on SLAPPs and are playing an active role on the question of how best to tackle issues around ethical professional misconduct within that forum. Engaging widely in this way will enable us to develop a comprehensive categorisation of types of professional ethical misconduct that might require regulatory attention, and to analyse how many of these already engage regulators' existing codes of conduct. In this way, we can begin to better answer the question as to how regulation can best play its part. This might lead to proposals which require regulators to identify any weaknesses in current regulation and adapt their regulatory infrastructure accordingly. It might equally lead to regulators needing to put more resources and more determination into enforcing their existing rules to ensure there are consequences when legal professionals engage in the kind of conduct that facilitates SLAPPs and other kinds of behaviour which is not consistent with the professional principles and upholding the rule of law. Perhaps the answer will be a combination of both. But there's plenty that the profession can be doing in the meantime to rid itself of the behaviours that fall short of the high standards that the public rightly expect. Our ambition is for the role of legal professionals in upholding the rule of law to be embedded in workplace culture to help legal professionals with ethical decision making. There's no magic wand that regulation can wave to deliver this. It's part of the picture, but it needs to be a collaborative effort with strong leadership from within the profession to drive up standards and put adherence to the professional principles before profit. We'll continue to play a leadership role on these issues, bringing people together across the sector as we strive to ensure that the UK is not only recognised across the world as a centre for international legal services and dispute resolution, but also as the place where the highest standards of professional ethical conduct are never in doubt. Thank you.
Okay, thank you. Let's see if we can get back to Susan on a better line. Susan, are you back with us?
Does that work better?
Yeah, well, we can hear you. Have you have been able to solve the feedback problem?
Yes, certainly from my end.
Okay, so, all right. Why don't you pick up where you left off?
Yeah, thank you very much. I mean, I think it complements what's being said, because I think this issue about the early stages and the pre-action letters as the moment where the damage is done in terms of really having a chilling effect is really important. And I hope we can have some kind of detailed discussions about how you go about tackling that. I think just wanted to highlight, really clearly a case where that had a direct impact on reporting. And earlier this year, there was a very big report by the BBC and Evening Standard after a Conservative Party donor who'd been seeking anonymity in the courtroom had been implicated by the NCA in a case involving a laundromat. And there were genuine questions that should have been put out in the public domain about whether this was part of a foreign influence campaign. We supported the journalist's request for transparency in this case. But as soon as the judgment went against the individual, the lawyers acting for the claimant wrote letters very widely to lots of news outlets and MPs, meaning the story didn't really get much wider coverage or the attention it deserved. And I think that poses some kind of interesting and serious ethical questions about law firms engaging in aggressive reputation management for their clients at the same time as representing them. I just wanted to highlight a few reasons why it matters so much as well. I mean, we know from talking to officials in the Foreign Office that the UK sanctions regime, for instance, rests very heavily on open source material, particularly when it comes to corruption allegations. But if that material isn't getting into the open domain because of threats, then it seriously impacts the ability of the UK to use that regime ambitiously. I think also law enforcement, they use a lot of open source material and feeds from journalist articles or NGO reports as the start of an investigation. And journalists don't, as a rule, share their intelligence with law enforcement. So it really matters what kind of information gets into the public domain. And I think finally, the business community obviously relies on open source material as a starting point for its due diligence. And the Mercy Leslie judgment's just been mentioned. I think it would be, really good to see what, the details of the ruling in that, because that would have effectively made due diligence documents which weren't even published a legitimate target for defamation. So there's lots of really, really welcome activity going on. It's really encouraging to hear everything that has been said on the panel about how seriously this has been taken. I just wanted to reiterate what Richard just said about the ethics, though, that is behind this, because I think the bar for being kind of declared a SLAPP or actual abuse it is quite high. I mean, we've had, one law firm that we sent a right to reply letter saying that they would sue us if we ever mentioned their name in a controversial context, just because our name is Spotlight on Corruption. That's not a SLAPP or it's not threatening, but, it will, obviously has a kind of serious impact on our appetite and willingness to really mention any material relating to that law firm. So I think that issue of how we tackle this early stage, the threats early on, and how high the bar is that we're setting for ethical conduct are key things I'm hoping that we can discuss.
Okay, thank you, Susan. So, I mean, I think what Susan was suggesting there was, what more can be done in terms of the non-regulatory activity that might not be captured by either the economic crime bill or anything else in terms of the stuff that never gets to court. Does anybody want to say anything about that in terms of, what more Juliet, the SRA, thinks is possible in terms of working with either civil society or other sources to actually, deal with this before it gets too big a problem?
I mean, I think I would just say I completely agree that from what we've seen and what we've heard, it is often just those pre-action stages where so much of the activity happens and sort of threats are made and issues really kind of crystallise. So completely agree with that, and we are working. Very grateful for the work that Foreign Policy Centre are doing and talking to them to try and make sure that we can get more insight into some of the kind of correspondence that people are receiving way before anything might get to a court, so we can understand better what people are receiving, what issues that brings to light. I think that from a large number of the cases that we have, it is also clear that that's where sort of matters crystallise. And what we've tried to be clear in our warning notice, which was last November, is it is not just about when cases go to court. It is about the way in which you engage in those early letters and the correspondence. And when we say you shouldn't put forward a claim that isn't properly arguable, we mean actually you shouldn't advance a case, whether that's through correspondence, not just when it gets to court proceedings. So that's something that you know, we've made clear, and as I say in quite a lot of our cases, that's where issues arise. And I think that you know, one of the clearly some of the sort of the things that the new legislation is trying to address is the kind of court's power to deal with cases when they come before them, and the power to strike out, and obviously the kind of consequences that might follow in terms of costs. I do think that helps give a sort of, you know, have a sort of knock-on effect though, to, you know, what solicitors should be advising clients at the outset, and, you know, the kind of clarity that gives of, you know, how the courts will view certain types of claims, and you know, the flag that gives of the types of claims that they shouldn't be taking on the instructions in relation to in the first place. So I think that it has a kind of positive knock-on effect, albeit that it's sort of directed at the court stage.
Because I mean, that's good to hear. Because when you first started speaking, I thought when you were saying that the powers of the SRA are not contingent on that legislation, made me think, well, has this legislation actually done anything of any you know, real difference for you in your work? I mean, has it?
I think it's going to be hugely helpful when it comes in, and obviously we've got to wait for the civil procedural process to sort of take place before we can see how it's going to be, you know, put into effect. But I think for that reason it will be helpful. It provides some clarity in terms of a definition of a SLAPP and what the courts are going to consider to be unacceptable, which changes culture, gives us that ability to say, look, if you see these features, that's you know, that's an example of what you should know in advance. You shouldn't be taking forward in the first place. The point that I was trying to make is our powers aren't limited to just being able to deal with something once it's been labelled a SLAPP by the court. It's not just limited to economic crime matters, which obviously the legislation is directed towards. What we do is enforce against our regulatory framework, so that allows us to actually sort of take action, and what, you know, our scope is broader, and our ability to deal with these issues is wider than that. That was the point I was trying to make.
Okay. And Sam, I thought when you first started talking, you were going to tell us that you know, in terms of your three issues, what's the problem, what action is necessary, and will it work? That there wasn't a problem that needed fixing. But you clearly sort of do see that there is a real issue here. But I think if I'm understanding what your argument is that by the time the barristers are engaged, this is not something that you feel is necessarily, I mean, well, let me put it another way. I thought that you were a bit, you seem to suggest, you glossed over the kind of codes and the sort of the regulatory type of standards and structures that are there to uphold conduct and to which people should comply, a profession should comply. Is that because you feel that you've already got that covered, or?
Well, I think you're right. I think the problem is likely to be post-Economic Crime Act, more in the very early stages, and certainly the things that those individuals I mentioned have reported. It's the aggressive nature of correspondence and so on. Those typically come from solicitors. So I do agree with Juliet, though, that what happens at court later on absolutely affects the whole approach that lawyers take, by which I include barristers, throughout a process. So if you have a judgment which identifies, well, this is a SLAPP, or when we have this act coming in, at some point it will be caught by cases, that will inform and how all lawyers act, and that will, I think, change culture in the way that Juliet suggested. But I wanted to just raise one point, and Susan Hawley raised, that perhaps the bar is too high. And I just want to posit 2 points that Juliet mentioned when she spoke. First was that you should avoid unfounded or exaggerated claims. And then when you spoke a second time, you talked about cases that are not properly arguable. There's a difference between those two. we must be consistent across all sectors. Not defamation isn't unique on its own. A claimant can bring an unfounded, and frankly, I'm in building and construction engineering, and one side or the other always exaggerates their claim. That's just how life is. It's when it's not properly arguable, it's when it's an abusive process, and that may be for a collateral purpose, such as trying to suppress the work of an individual by going after their organisation or vice versa. That's where we have to come in. But we need to be quite careful about this idea that you shouldn't be taking on instructions in the first place, because you know we have a fundamental right to be advised and to representation. So I do think we need to be careful about this question of where the bar's set. And I would much prefer to see these examples at the end of the track in judgments, which then inform, as they do in every other sector, how the lawyers conduct themselves, how they advise in relation to particular types of claim.
Okay, Richard, do you want to say anything on that? And then I'm going to invite Charlie to give us a few reflections.
Thank you. Yes, I would like to say a few things. I mean, the first thing I think I would say is that you have already set out in the Legal Services Act a set of professional principles which all legal professionals must adhere to, which go to, for example, serving the interests of justice and independence and integrity. And arguably, some types of conduct that, for example, relate to the exaggeration of a claim, you know, bring into question those kinds of principles. So I would say Dr. Hawley is quite right to point to the bar being quite high for SLAPPs, but when you look at where the bar is intentionally set by Parliament around the conduct of legal professionals, it is set at a level which allows regulators to bring in and enforce rules and guidance that are there to drive up standards and ensure that these types of misconduct don't appear. It's down to regulators and leadership in the profession, I think, to change culture, to really make sure that has the effect that Parliament intended when it put in place that legislation.
And when you talked earlier about reviewing the existing rules of conduct that exist within the profession, is that something where you feel at the moment, as in the Legal Services Board, feel that there are too many different sets of codes and this needs somehow bringing together and clarifying, or are they not good enough? Or
so it's right that the legal services regulators have codes of conduct that are tailored to the risk that is there in their profession, the profession they oversee, the sector of the profession they oversee. What we're concerned with is ensuring that there are clear principles that are common to the legal services sector, and ensuring that regulators have the resources, the will and determination to see through and uphold their rules where they are being breached. You know, it's not always the case, I think, routinely, that happens at the moment.
Okay. All right.
Can I just respond on just the point about regulation? And I mean, I think it was slightly unfortunate Richard talked about the professions generally putting the professional principles before profit. The SRA have carried out their thematic investigation. They've got 55 live cases. 19 have been dismissed. 2 they've recommended for tribunal. We need to see some of these cases coming through, because at the moment there really isn't very much evidence of solicitors, and certainly not the bar, putting professional principles, putting profit before professional principles. And so before we start changing the whole architecture and throwing it all up, we need to see some examples coming through the regulators. And absolutely, if there's misconduct, it should be slapped down. But we haven't seen that yet.
Okay. Well, some of our audience may have some questions on that. But just before I go to Charlie, when are we going to see the outcome of any of these cases that the SRA have been conducting?
Well, as I said, we've got 2 that have been referred to the tribunal already. So they're going through the process and will be the allegations will be published and the hearings will take place before too long. We've got a handful more where we're going to be making the decision to refer them. So hopefully shortly we'll be able to talk about those individual cases, which obviously I can't at the moment. I wanted to if I might just talk about the numbers, because I did want to come back on the point that you made. I think it's important not to read too much into the findings from our first thematic review that we didn't see any individual cases of SLAPPs. As you say rightly, I have said before, and we have said before, that wasn't the purpose of that thematic review, and we specifically took a sample of firms which didn't include any of the firms that at that point we were already investigating, where we had heard that there were concerns in relation to their behaviour. So I think we just need to be very kind of careful in drawing conclusions from that review of 50 case files in that selected sample of firms.
Okay. All right. I think now might be a good time to invite Charlie Holt, who is the co-chair of the UK, you all probably know him, but the chair of the UK Anti-SLAPP Coalition and the Coalition Against SLAPPs in Europe, Legal Ethics Chair. Charlie, what's your perspective on what we've been talking about, and also from the kind of from the angle of other jurisdictions?
Thank you. Yeah, I'll try and make 2 quick points. I'll be looking at my time to do so. The first one, as you say, would be in my capacity as co-chair of the UK Anti-SLAPP Coalition. And then secondly, I do want to look at the European perspective. First of all, just from the UK Anti-SLAPP Coalition, I wanted to start just by clarifying our position on this. We've long since recognised that this is a thorny issue, replete with grey areas. It's a tricky area. We're also under no illusion that there is a problem here, and it's a problem of accountability. It's a problem of accountability we've been attuned to for years. I was talking to Dalia earlier today about one of the complaints that was submitted by the Daphne Caruana Galizia Foundation a few years ago. We've heard about the 47 cases that were pending against Daphne Caruana Galizia when she was assassinated. Still no accountability, still no justice for Daphne, but still no accountability about the lawyers who facilitated those lawsuits, the lawyers who engaged in tactics designed to harass and intimidate Daphne Caruana Galizia. A huge campaign of harassment, and still nothing from the SRA and from other regulatory bodies. We have seen a growth in the number of SLAPPs, we've seen a growth in the shamelessness of SLAPPs, but we have seen no disciplinary action taken against the lawyers who are largely responsible for the lawyers for the arguments and tactics that have been advanced. And I think it's important there to clarify that this is not a matter of conflating lawyers with the interests of their client. We're not trying to dismantle the cab rank rule or do away with a principle of non-discrimination. It's not about that. What we're trying to do is to uphold the duty of a lawyer, to uphold the duty to act with integrity and to promote the proper administration of the law. SLAPPs represent an improper use of the court process. They are by very definition abusive. I think that's a really important point to emphasize, because lawyers should not allow themselves to become instruments of this abuse. And that is why we are pushing for this type of reform. The warning notice has been raised a couple of times, and it was an important step. It is an important step in delegitimizing the use of SLAPPs. But to state the obvious, it's not enough on its own. And I think this is something which I would agree with Sam on, which is that in the abstract, the principles which have been expounded on in the thematic review are still too ambiguous to provide any sort of deterrent for the type of wrongdoing we know exists. We need to see these principles tested and applied in order to fully disincentivize the use of SLAPPs and SLAPP tactics. Juliet's presentation, I thought, was very encouraging in this respect, but we still see in large parts of the legal profession a certain amount of complacency and even denial. And I'm very grateful for Juliet for clarifying that last point at the end, because we've heard this the thematic review being misrepresented in large parts of a number of parts of the legal industry to suggest that there is no problem. And as Juliet has now clarified, the thematic review excluded any firms in the investigative that were pending the investigation of the SRA. That's a really important point, because one thing that distinguishes the UK from other jurisdictions isn't the existence of SLAPPs, it's the existence of a discernible SLAPP industry. We see time and time again SLAPPs being put forward by the same law firms. If these law firms are the same law firms that have been excluded from a thematic review, it's perhaps no surprise that we didn't see existence or conclusive evidence of SLAPPs in that thematic review. So I just wanted to clarify those points, both about our own position, but also about the SRA and about what's been going on more recently. I'll say one more point very briefly, if you let me, and I apologize for going on, but just about Europe. I also sit on the steering committee of the Coalition Against SLAPPs in Europe, and we have been working for a number of, for about a year or so now, on a comparative analysis of regulatory standards, codes of conduct, and best practices across Europe to hold lawyers to account. And in this process, we've been paying close attention to what's been going on in the UK. And I know we're not alone in this inquiry. There's a number of questions, important questions, which are floating around the entirety of Europe. Questions such as, is this a problem of enforcement? Is it a problem in the codes itself? Are existing codes of conduct sufficient, or do we need to see regulatory reform? Indeed, the recommendation that accompanied the draft directive that was published by the European Commission last year explicitly says that member states should be encouraged, or rather should encourage self-regulatory bodies and associations to align their deontological standards, which includes codes of conduct, with the recommendation. So this is something which bar associations across Europe are currently looking at. The CCBE, which is an association that gathers law societies and bar associations from across Europe, from 32 countries, has therefore been constructively engaging in this issue. And I will just end on that note, because all of this underscores one very simple but very important point, which is that what we do in the UK will have implications that extend far beyond these shores. It's really no exaggeration to say that the world is watching what we do here. So it's so important that all of you are engaging this issue. And while I might push back forcefully on some of the points made, I do want to encourage you to stay engaged in this. It's really important that we do get this right. So thank you very much for your time.
Okay, thank you. Thanks, Charlie. Okay, just very briefly before I go to Juliet, because that was quite a sort of strong point directed to the SRA in terms of the one of those specific cases. Is there anything you wanted to say in response to the actions that we're still waiting for from the SRA in terms of actually concluding some of these live cases?
I think no more than I said already, which I totally recognise the point, totally accept that, you know, it's really important to get these cases through and tested and heard, and that we are, you know, working hard to do so, and as I say, you know, reaching the point with some cases where we should get to that. And I also just did want to say that I totally accept that a warning notice doesn't stand on its own. However, what I do think is encouraging to see is that, you know, regulation, as I think Sam who said, you know, that there's two things. One is after the event taking enforcement action when something goes wrong, and the other is actually trying to drive cultural change. And what we're starting to see green shoots of with this latest thematic is that the warning notice and the noise that we are, you know, creating around what is and isn't acceptable through that notice and the other things that we're doing, you know, does start to drive some cultural change in terms of how people are approaching, you know, particularly as we've seen some of the sort of pre-action letters and correspondence.
Okay, well, hopefully it's driving cultural change in the law firms where they need it most. We'll move to questions from the floor. We've got roving mics, so would you like to, the gentleman here at the front.
Thank you, John Spain, Consulting Actuary. SLAPPs are really important, which is why we're also grateful for the amount of time and attention that's been paid at all levels. However, SLAPPs are big money. They're really the Premier League. And Richard actually mentioned it when he was speaking. And that is, and it was mentioned this morning as well, whistleblowers. They have their own legislation already. It really doesn't work. And you've got exactly the same problem of lawyers going after the targets in exactly the same way as SLAPPs. And yet, despite many approaches to the SRA do not appear to be interested at all. And I really have to ask why that is, and ask Richard to note that when it comes to it, they should be included in the other victims heading.
Okay.
Can I just ask one?
Well, we've got quite a few people trying to ask questions. So I think what we'll do, we'll take a couple of questions before we go back to the panel. So we've got a lady here in the cream towards the front, and then we'll come to the gentleman behind with the glasses.
Yeah, it's Ursula Smart here. I'm also a legal educator, as in I teach on one of the law degrees at London University. And given the fact that you don't need to have a qualifying law degree anymore to be a lawyer, I just wonder what the regulators are doing in terms of legal education. And I have educated my students about SLAPPs. I'm currently going around the country lecturing on SLAPPs. But how are we, or how are you, the regulators, the bar? I know you have to abide by the cab rank rule. I think that's what my students know. But the result from your survey, from the SRA survey, that your lawyers, your qualified lawyers, were not really aware of regulation that exists, and the same with the Legal Services Board. That's worrying. So you can now have a mathematics degree or a history degree, and you go straight into the SQA and into the bar professional courses. Is anything being done in terms of legal ethics, which we haven't got time for anymore to teach?
Okay, and then we'll just take the gentleman. Yes, that's right, just on the end there. Thank you, and then we'll go back to the panel.
Thank you. My name is John Heddershaw. I'm Professor of International Relations at the University of Exeter. I've been a subject of various pre-action letters of an egregious type for research which is cleared by my University Ethics Committee. And academic ethics is such that you don't do all forms of possible social research. We don't do Stanford prison experiments anymore. And whilst I accept the cab rank rule for criminal law, I do not and cannot accept, and like it explained to me, how that should apply in matters of aggressive legal action to defend reputations, which is in civil law. Because in my ethics, we choose not to do certain forms of research. And I think civil law, with respect to that kind of aggressive action by wealthy people against whether it's journalists or academics or whistleblowers or anyone else, is not really acceptable. So I'd like to hear Mr. Townend defend that in language which works outside of the bar. Thank you.
Okay, all right, thank you. So let's come to you first, Sam, to deal with that question in terms of how does the cab rank apply when you know these should be matters where you've got a choice whether or not you take on some of this work. And I think if you could also, when you've dealt with that, deal with the question about what are you doing in the bar to teach members more about SLAPPs? Yes,
of course. So I'll take the last question first, if I may. The cab rank, as you know, was implicit in what you said, applies across all sectors of the bar. We believe that and it also comes lawyers shouldn't be associated with the causes of their client. They are independent. The bar in particular owes duties to the court and as well as to the client, and of course to litigants in person on the other side. There's a whole spectrum of responsibilities there. The cab rank, which is the thing that you referred to, applies that we cannot, like the black cab on a cab rank, we can't turn down a case if a reasonable fee is offered and it's within our area of competence, that we must take it. And that applies as much to an oligarch as it does to someone who's seeking asylum. That's just for the purposes of access to justice and the good administration. That is how it works. But if it is indeed a case where it is not just aggressive, because aggressive court actions can happen, but where it crosses the line into being misleading an abusive process because brought for a collateral purpose, which is, I think, possibly along the lines of the sorts of things you were saying, then we would be professionally embarrassed and we have to withdraw. So the framework in which we work is, I think, quite clear. Some of it is quite well understood because we've had 2 references to the cab rank. So moving on to legal ethics, we have a host of legal ethics training through what we call bar school, which is through the vocational training. You then have ethical training through your pupillage, your traineeship, and the Bar Council itself provides an ethics hub which has a host of different information about how you should behave in certain circumstances. We also have, separately from the regulator, our own ethics hotline. So we have 11 members of staff who do other things as well, but they also answer queries. And in fact, on the cab rank, we do receive inquiries from people who would rather not do cases because they find the client unattractive or whatever it might be. And more often than not, the advice is, well, I'm afraid you've got to take it. And then behind that is a whole panel of barristers and King's Counsel who in the unusual cases or the most difficult cases can be called upon. Again, this is all for free to give advice. So that's, I completely agree just on legal education. I wish we could invest more as a country in legal education to all our children, because that would make life a lot easier if people understood their basic rights. And also, if I may add to that, first-tier advice, citizens' advice, law centres, they've been decimated in the last 10 years. If we could have some sort of legal advice centre in every constituency in the country, it would make a parliamentarian's life a lot easier. And that's one of the things I shall certainly be campaigning for to be in all the parties' manifestos at the next election.
Okay, Richard, was there anything that you wanted to add about what regulators can do to teach the profession more about SLAPPs?
Yes, thank you. And so we introduced new rules last year on ongoing competence, which require regulators to have in place robust and fit for purpose mechanisms for ensuring that the legal professionals in their areas come through qualified and not just actually at the point of entry to the profession, but there are points throughout the lifetime of a legal professional's career where they are tested and where when legislation is being changed, they are made aware of it, and that's brought into their training. The other point I would just make, if I may, is, I mean, the cab rank rule is there, and Sam's talked about it, but of course it's the discretion of the barrister to choose how they represent somebody who is next in line, and that, of course, is a question which I think is ripe for an area that's ripe for questions about ethical conduct. So I just thought I'd mention that as well.
I think that's a really important point, because I think in any profession or any kind of industry, the people who are members of it have a duty to uphold its reputation by how they go about their work, not just what it is they do in their work. And that's where people gain their confidence from that profession or not, as the case may be. Okay, let's go back to more questions. There's a gentleman just there with glasses, and then a lady on the side there with glasses, and then we've got a gentleman at the front here.
Hi, I'm Gavin Stewart. I write mostly on financial regulation. Given the extreme wealth of many of the perpetrators of SLAPPs, and that winning the case is often not their main purpose, are you confident that legal services regulators have the powers and resources to deter SLAPPs? So that the regulation's not just seen as a cost of doing business. And then related to that, given their wider impact highlighted in the Russia report from the ISC and elsewhere, and that they're used as a shield for economic crime, do you see any scope for involving other regulators who have a remit to do with financial crime and wider city regulation, such as the Bank of England, FCA, City of London?
Okay, all right, thank you. The lady on the side in the purple jacket.
Sybille Raphael, I'm the legal director of Protect, the whistleblowing charity. We talked about accountability. If the legal regulators are serious about enforcement, they should encourage the workers, the lawyers or the solicitors, to report the wrongdoing committed by their law firms or their pupil master or the QC that is leading them. After all, the workers are the eyes and ears of an organization. So it seems rather strange that, although in the financial sector, the financial regulator is very clear that every single financial institution has to have effective whistleblowing standards, have to have policies, have to have training, have to have a senior manager who's a whistleblowing champion. None of that in the legal sector, which doesn't help with our reputation as the dirty capital of Europe, especially when in the rest of the EU there are now standards imposed on any employer who has more than 50 workers. So is it something that the regulators are looking at? And we've just seen that the Bar Council is going to publish a template whistleblowing policy, which is of course very welcome. But couldn't just we go a little bit further? And that wouldn't change, you know, it's not a scary regulatory change. It's just telling those law firms, those organizations, look, you need to tell your staff how to report wrongdoing. Okay. You need to tell your staff how to go to the SRA, how to go to the Bar Council when they see a SLAPP. Just as simple as that.
Thank you. And then finally, the gentleman at the front here on the end of the front row.
Thank you. It's Nick Williams from Index and Censorship. I feel like we sort of buried the lead in the last back and forth about the cab rank is the how. So barristers, the how they, because yes, fine, they maybe how they select their client, well not select, but how they are working for their client, but it's them themselves in conjunction with their client who outlines their strategy. But when that strategy itself may fall outside of the codes of conduct or may be overly aggressive, ignoring the usual, what's the term, rough and tumble of whatever that is, but what checks and balances and what sort of safeguards are there to ensure the strategy of the barrister does not help further or turn, because as was mentioned in the last panel, there may be a legitimate reason for bringing a defamation case, but it's the how it's brought about that moves it into SLAPP territory. There is obviously a responsibility of the barrister to determine their litigation strategy in line with, you know, best standards. So what checks are there to ensure that a barrister doesn't fall outside of those? Because I feel like we've not really nailed that.
Okay. Right. Well, why don't we go to Sam first to say something about the how?
Yes.
And Richard may want to follow up on this as well. So let's start there.
Okay. I'm just going to respond just in one sentence to the point you meant. Every barrister owes a duty to report any serious misconduct that they observe. So there is a duty to report it to the Bar Standards Board. Yeah. So that is the case already.
So that. Okay, so we need. There's a plea there for greater promotion of whistleblowing routes, and the fact that there's a responsibility on people to do that.
Yeah. As to litigation, the how, my own view is that when you are once you're in live proceedings, the way you get your way with the court, or as far as possible, is by being reasonable. Judges are forever on the lookout of what is a reasonable approach to litigation. And the judge always has to balance the interests of both parties when it comes to questions of case management, which is where the strategy would come in. And so an obviously overly aggressive approach would, in my experience, whether it doesn't matter what field you're talking about, building and construction, you're not going to get your way, and it will be unattractive, and you may get costs orders against you. So I think once you're in live proceedings, the checks and balances, because of this question also, we as professional individuals are always thinking about our duty to the court, as well as to our client, and indeed to those who are unrepresented on the other side. It's what every barrister does, every professional barrister does. So the question I think then might arise in what about in very early circumstances where you're asked to draft a letter and so on. And I can see how that is quite a difficult situation. But equally, I find it difficult to know how a barrister receiving, and this again happens in all fields, receives a small file of documents with some instructions and said, you must spend, please spend 3 hours drafting a letter. There's only, you have to sort of take it as it comes and respond on that. So at that point, I suppose you're not doing the strategy. But I think when it comes to litigation strategy, definitely the reality is you are generally required to do it reasonably, and you must advise that too, because there will be sanctions for your client ultimately if you don't.
Okay, I'll just ask if Richard wants to comment on that, and then I'm going to come to Juliet to talk about powers and resources and collaboration with other regulators. Richard?
Yes, I suppose the point I'd make is, wouldn't it be good for the interests of justice and for society if, rather than waiting for a judge to, call a barrister out on the way they're behaving, there were better ethical standards and rules and guidance in place that made sure that that line was never crossed in the first place, because it was built into training and built into the culture of the profession that you act in a way that is in the best interests of justice being served, and we don't get into this sort of overly aggressive litigation strategies that can sometimes undermine justice being served. So I think there is a role for regulation. It may not be hard rules, it may be guidance, but there is a space there that needs to be filled with something around driving up standards of ethical conduct, so we don't have to have these debates about who's crossed the line and who hasn't.
Okay, Juliet, what would you like to say about whether the SRA has got the powers and the resources now to deter SLAPPs, and what are you doing to collaborate with other regulators that could assist here, like the FCA or the Bank of England?
So just to say, I completely agree with you that you need to be able to, have the powers to make sure that, any action can't just be seen as a cost of doing business. So having sort of a proper deterrent effect is hugely important. And that's one of the reasons why we're really pleased that the Economic Crime Act is bringing in sort of removing the kind of cap on our fining power. So we'll be able to find some of those large firms a proportionate, attach to their turnover a significant fine for misconduct when we see it. So just to say that, I completely agree with you, and that's something that obviously we welcome. We do work together with the FCA and the FRC and other regulators. I mean, I think I can't say we've had any specific conversations around the work we've been doing on SLAPPs, but I think that's a really good call, and we'll obviously build that into our ongoing engagement with them. I wanted to make, just because I know the time is tight, just one last point, which is to say that for solicitors firms there is also an obligation to report matters to us, but also we have an individual who is the equivalent of, I suppose, your whistleblowing person within the organisation, which is the compliance officer, whose responsibility and accountability is to make sure there are policies and procedures to encourage reporting, and then to make sure that things do come through to us. So I completely agree, clarity around those policies is hugely important.
Okay, this is clearly a session where we could go on, but sadly we have to draw it to a close because you have other very interesting sessions that will follow. But can I thank, on behalf of you, my fellow panellists here, and also Dr. Susan Hawley, who has been joining us throughout online, and to Charlie for his contributions. I think the big takeout from this is just how important the legal profession is in, to state the obvious, in making sure that our legal system is not subject to abuse, and the expectations that those who are on the receiving end of this action have of the legal profession in making sure that they do their uphold their responsibilities in a way which is fair to all and doesn't in any way undermine our legal system in that process. So, but thank you all very much indeed. Thank you.